He's over there.
For who? I'd like to convene the commission again so we can go over the rental licensing. Mrs. Ridley, do you have anything beforehand?
Of course.
I know you do.
As we read the public comments received during some of the public hearings on the master plan process and listened to the public conversation that took place, it started to become clear to us that there might be some misconceptions about rentals throughout our city. So our goal with this work session is to first have building official Brian Kench give some information to you about, and the public about what kind of rentals can exist in what zoning districts in the city. And then Fire Lieutenant Mike Dunham, who heads up our Neighborhood Resource Unit, will give you a perspective of the number of rentals, the number of complaints he and his department investigate each year, and in general how that complaint is pursued so you have an understanding of the process that must take place. After the presentation, certainly if you have any questions, we'll attempt to answer them, and if we can't, we will get back to you. So with that, I'll turn it over to Brian.
And we vowed to get you out of here before 10 o'clock, so.
Good.
I'm going to go through this really quick. I think Mike's got the bulk of the presentation when we talk about rentals. I think if you've watched the Planning Commission over the last few months, you may have seen some of these slides. We've tried to recycle as many as we could to keep the message consistent. But essentially what we're going to go over this evening is just provide an overview of our rentals throughout the city, how we define our rental units, both in the zoning ordinance as well as state law. Zoning regulations, where these units would fit within our standards, and then of course Mike will talk about licensing regulations and how we go about putting them in the program. And then we'll just briefly touch on the data that we have to be able to track and do trending and so on and different things within the neighborhoods. So what do rentals look like? As we've heard over the last few months, we've focused a lot on rooming dwellings and RSO dwellings, but they're made up of single families, duplex dwellings, which were two units designed for single family living, apartment complexes, both made up for family living and multi-family rooming dwellings, and then rooming dwellings, which could be a converted home or multi-rooming dwellings or RSO dwellings that are recognized by CMU. And then just some photographs here to kind of depict each one. So regulations, how we define them. Legal definitions as provided for under uslegal.com identifies it as any dwelling unit that is offered for rent, lease, or hire for which is rented, leased, or hired. Seems to make it clear as mud there. Our housing and licensing standards talk about any and all rented or leased buildings, including manufactured homes or any portions thereof that are used or intended to be used for human habitation. Very similar to the definition that is also provided in the Michigan Landlord and Tenant Relations Act, PA 348 of 1972, which is, provides for tenant and landlord relations. So as we look at, we're going to look at 5 basic types out of the different zoning classifications that we have. There again, one family dwelling is defined as a building used exclusively or designed for one family occupancy. These are definitions directly out of our zoning standards. Two-family dwelling is a building used exclusively or designed for the occupancy of two individual families living independently of each other, and then a sample of what that might look like. Rooming dwellings are buildings containing one or more dwelling units that are approved for use by 3 or more persons. Zoning ordinance defines a family as the traditional family or no more than 2 unrelated. That's how we get density in both our dwelling units, our rooming dwellings, as well as our RSO dwellings. RSO dwellings are very similar in nature to the rooming dwellings. They do have a little bit more parking requirements that are attached to them. They allow for other activities on this site, and they allow for some signage to be placed on the building to recognize the RSO. RSO has to be registered with CMU to be eligible for the zoning approval. And then multifamily dwellings is the last one that we'll look at this evening. Give you a picture of Yorkshire apartments down in Broomfield, as well as the Rivers Bluff units down here on Broadway. Building containing 3 or more dwelling units is what we would anticipate as a multifamily dwelling. Zoning regulations, and I'm going to go through here these really quick. Dwellings permitted by right in the agricultural districts are one-family detached dwellings. The R dwelling, which there's 4 different classifications, R1 through R4, each allow one-family or single-family dwellings as a use by right. 2-family dwellings are permitted, but they are regulated under a special use permit approved by the Planning Commission. M1 district allows for 1- and 2-family dwellings along with multifamily dwellings as used by right. They are subject to site plan approval before the Planning Commission. And there are nothing to report under the special use permit under the M1. As we start going deeper in here, I think Commissioner Link pointed out some of these take in a lot of the other uses in their district. The M2 permits 1-family, 2-family dwellings and multifamily dwellings, all as uses by right. They're again subject to site plan approval. And then, of course, rooming dwellings and RSO dwellings are uses that are permitted in the district, but they are regulated under a special use permit. OS Office Service District allows for single-family dwellings as a use by right, and then under a special use permit, they do allow for 2-family dwellings. They do require some increased lot area to be considered. C2, we allow a little bit of residential, but it does have to be located on the upper floors. And then, of course, under the overlay, we allow certain residential units under mixed-use developments under part of that overlay as approved by the Planning Commission. So with that, I'll give you kind of the nuts and bolts, where they fit, where you'd expect to see them in the zoning ordinance, and we'll turn it over to Mike to kind of talk a little bit about the process for securing a rental license. Commissioner Kulik?
Just one question. Mobile homes in a mobile home park, if they're family-owned, you do not inspect them. If they're a mobile home that's rented, that's considered a rental unit, but an owned mobile home in a mobile home park is not considered a rental, correct?
Correct.
Thank you.
Mm-hmm. With that, unless there's any further, yes, Commissioner Lane?
I just wanted to ask a clarification question, too.
Can you bring your microphone
Oh,
down?
yeah, sorry. I was eating some of the trail mix, and so that's why I put it up there, sorry. You're defining for us what residential is in multifamily, but in the issue of the number of people living within a single unit, not how many units, but the issue of how many people are in a single unit. If there are 3 or more people in a single unit, renting, or owning for that matter, but renting, can that rental be in any zone other than an M2 zone? Could you have a rooming dwelling in an R2 zone, for example?
You could. We may have. Throughout the city, there's a number of non-conforming uses that have been established. As Commissioner Kulik noted earlier, those uses can remain until the end of time. Any new use that would have 3 or more individuals would have to be under a special use permit in the M2 district. It's classified by our definitions as a rooming dwelling at that point.
Okay, so if you already have a rental license that was established before there were restrictions, then that rental license is still good, and you could be in an R1 or R2, but you couldn't get a new rental.
That is
okay,
correct.
Thank you very much.
Yep. Are there any other questions? All right, we'll turn it over to Mike.
Good evening. I'm going to walk you through the rental licensing process from the inspection point of view at this point. Once the Building Safety Division receives the application and approves it, they hand it over to the fire department. We ensure that the fees have been paid, and we schedule an initial inspection. We look at 2 different types of properties when we are out there doing inspections, occupied and unoccupied. Licensing an unoccupied rental is slightly different than an occupied one. Using the Housing Code and the International Property Maintenance Code, we inspect the entire residence, identifying any violations that may exist. If no violation is found, the property is immediately licensed and the property is allowed to be occupied right away. If we do discover a violation, we allow the property owner adequate time before scheduling a reinspection to correct the violation, but it's understood that they're not to allow the occupancy until all corrections are made. We have 2 types of occupied rentals in the city. We have properties that are occupied by unlicensed rentals. They've never been licensed before. And these are possibly people that are just starting to rent for the first time. They want to fill out an application and rent it for the first time. Or it may be people that are already occupying it as a rental. They just aren't aware that there's requirements to license in the city. And then there are those that the owners are very aware that they need to license it, but they just didn't comply with those requirements. Then we have properties that were licensed, but the license is expired and they're going through that renewal process. But either way, whether it's unknown that they were supposed to or that they are just renewing it, the same exact process takes place every time. An initial inspection is conducted on an occupied rental. If there are no violations, again, the license is granted right away. It's approved for a year. If we do find violations, however, because the property is occupied, the owner would have 48 hours to comply with a correction that might be hazardous to the health of the occupant or the community. And then all other violations, they would have about 30 days to complete that process. During the reinspection, to verify all the violations that are corrected, we're going to do one of three things. We're either going to issue the license because all the violations were corrected, we're going to schedule an additional reinspection, and then there's a fee assessed with that second reinspection. That's half of the original licensing fee. Or we could issue a ticket due to little or no cooperation by the owner to correct any violations and for allowing the occupancy of an unlicensed rental. Here are a few examples of some common violations we come across during the inspection of both a previously licensed property or a brand new rental. And brand new doesn't mean brand new building necessarily, but it's a rental that's being rented for the first time, and we're looking at it for our first time. These new properties have a slightly different code set that applies to them. We also discover housing problems that exist in the community through complaints. Since the inception of the NRU, we have investigated over 140 different complaints, including over-occupancy, which you mentioned just a little bit ago, unlicensed rentals, mold issues, and lack of heat issues, which today might exist. We receive complaints from a myriad of different sources, including occupants themselves, neighbors, rental property owners, city staff, among others. The NRU has encouraged all city departments to keep their eyes open and to share information regarding potential problems, and oftentimes we are diligently working at correcting those problems before the community even makes a complaint. But depending on the complaint, you may spend very little time researching it, or you may spend countless hours attempting to resolve the problem. But it's always our goal to assist the complainant in resolving the issue, to be a resource for the community, and not necessarily to gain compliance through prosecution. I'd like to walk you through a process of a common complaint we receive, and that's an unlicensed rental. If we discover an unlicensed rental, we're going to do some preliminary work, and then the process discussed earlier is going to take place, and that would be approval of an application, a licensing fee is paid, and the scheduling of the inspection and the actual conduction of the inspection would take place. The timelines established in the housing code must be followed very closely. Documentation of all site visits, violation photos, inspection reports, phone calls, and emails can be very time-consuming but are necessary to be consistent from property owner to property owner, and also to make sure we are prepared if we are forced to prosecute. That preliminary work includes going to the city's website and checking out BSNA, which has all the property information on it. Who's the owner? Is there a principal residence exemption? Is the owner's address the same as the possible unlicensed rental? These are often telltale signs that an unlicensed rental exists. We're also going to make a site visit. Who's living there? Explain why you're there and try to gather as much information as we can. Once we have the owner's name and address, we're going to give them notice and also advise them of the requirements to license all rental properties in the city. But we're going to give them some time to work through that process, and that again includes the application fee, and hopefully we're going to at least schedule the inspection within 30 days. But many times this is where the owners have a lot of questions. They don't understand why they have to license it, so they have those questions. Why do I have to do that? And they're also going to ask, what kind of repairs am I looking at before I license this property? All great questions. We're going to document all those phone calls. In the end, an inspection is conducted, and eventually the license would be granted, or the property would be vacated because they chose not to rent it. But because it's a new rental, and that it's never been a rental before, it's not uncommon to have many different violations, including the list we mentioned before, including improper window size or smoke detectors incorrectly. We also have many other violations, including over-occupancy. Identifying a hole in the wall or an improper sized window is really easy. It's pretty straightforward. But proving a property is over-occupied is not as easy as you'd think. Over-occupancy issues can be created by the owner or the occupants. Some renters volunteer the fact that it is over-occupied and let us know that, and some aren't as forthright. But we must be discreet at times during the investigation so that we can obtain all the facts necessary. Counting cars and beds is not always a surefire method to verify that a violation exists. All the members of the NRU are working diligently to compile information regarding the over-occupancy housing violations. But whatever the violation, whether the property is over-occupied or there's a smoke detector missing, the owners and the occupants have generally about 30 days to comply with the violation during that initial inspection. Roughly 30 days later, depending on scheduling, we're going to revisit that property to verify that all the violations have been corrected. If the violations have been taken care of, again, they're going to be licensed, and they're going to be licensed for 1 year. If not, we're going to follow the appropriate steps to gain compliance, including the issuance of a ticket if necessary. If a ticket is issued, we're going to work with the city attorney. They're going to be prosecuting the owner or the occupant, and a timeline for completion is established. We're going to work very closely with the court system to verify that the work has been completed by their predetermined date. It's really an unknown number of days from start to finish, but sometimes it can be about 90 days. But when the property is finally licensed, the occupants are much safer and the properties are generally improved. Now, we've just described a complaint that occurs on an unlicensed rental. We also receive complaints regarding properties that are already licensed, and how do we deal with that? When this occurs, we conduct an investigation, which usually involves a property visit. If we find a violation of the housing code, we're going to give notice to the owner, and that includes what the violation is and when we're going to be back to re-inspect that property. Again, that's typically 30 days. That's what the code states. If during the re-inspection we determine that the violation isn't corrected, notice is given and a hearing is set for 5 days. The hearing is before the building official, the Department of Public Works Director, and the Planning and Economic Development Director. If after hearing evidence from the owner and the fire official, this panel feels the violation still exists, they decide whether or not they want to suspend that license. The panel then shall present in writing a decision to the fire official and the owner within 7 days. The owner can then appeal the suspension by going to the Housing Board of Appeals, and that within 21 days they have to do that. If the appeal to the Housing Board is taken by the owner and the board does not reverse that decision, the license is then revoked within 10 days. And if the property is still occupied at that point, we could issue a ticket for allowing the occupancy of an unlicensed rental. And as mentioned earlier, the court then decides the time frame for compliance. Again, this scenario takes about 90 days. That's just the way it ends up. But let me be clear, it's never our goal to write a ticket. That's not what we want to do. Our goal is to enforce the housing code, and for the most part, we do a really good job of that. If these owners make a solid effort to comply, we're very understanding as we can be. If the cooperation is not there, we're going to follow the timelines established by the housing code, and some are prosecuted. As you can see from the slide, 5,298 units were inspected in 2014, and only 5 tickets were issued. 3 for unlicensed rentals, and 2 for during the renewal process, they failed to comply with the requirements. We're proud of this track record, as compliance through cooperation is much better than through prosecution. We're also very concerned with customer service. That's the top priority for the NRU. We are in the process of streamlining our licensing and complaint reporting process. We want to meet the needs of all of our customers, and time is an issue for everyone. We want to be as user-friendly as we can be. We've been in communication with BS&A, and hopefully property owners will soon be able to fill out their application, pay all their fees, and schedule their own inspection at their convenience. Citizens will also be able to report code enforcement and other housing code issues online using a new form the NRU has created. We're really excited to offer this new way of doing business and are constantly trying to improve the service we provide for our community. I hope that, yes, sir.
Because of the way you made the presentation here, violations of the rental licensing is a criminal misdemeanor. It's not a municipal civil infraction. Is that correct?
It could be a misdemeanor, but when Fire Chief Walter House was here, we went away from that, and as soon as the property became unlicensed, we would then prosecute through a misdemeanor.
Okay.
Yes, sir.
So let's say somebody had purchased a house in a R1 for the sole purpose of having their son or daughter live there while going to school. And then through the son or daughter, they rent out 3 rooms to friends or whatever. So I think that's a common occurrence. So obviously that's an unlicensed rental.
That would be an unlicensed rental. As soon as they occupy by more than just their son, it becomes a rental in our mind, okay? If their son or daughter were the only ones living there, we would not consider that a rental. But as soon as they bring their friends and they become part of the process, that is a rental, and they have to go through the process of application, fee, and inspection. In this case, the example you used, they would also be overoccupied. And we would require them to go back to 2 unrelated. The person, the son or the daughter, would be 1, and they could have 1 other person.
Because anything beyond that, then they become a rooming house, right?
Right. The R1 that you mentioned would only be approved as a single family, which is 2 unrelated.
You have son and daughter living in the house, or 2 sons. They bring in 1 buddy.
That is acceptable because it's by blood, 2 unrelated. The 2 brothers
Are related
and
to
then
each
1
other.
other. That's correct.
One of the complaints that I hear from residents, some who are dealing with the kind of issue that Vice Mayor Routinen brought up, where you've got 1 person who bought the house and then they've got 3 friends living with them. And I'm sure you're aware that there are several of those, and my phone's rung off the hook a couple times with people saying, how come it takes so long? Now, we're getting some idea of that from listening to the description of what due process is, but this is what I heard someone say the other day. That due process takes just about a semester, and this is a college community, and so it just keeps rolling over, you know, so just as the semester's ending and it's dealt with in one situation, then different people are in there, and then the process has to start all over again. And so this person at least had the feeling of, yeah, some of these people who are running places, they know the system, and they know it takes so long to do anything about it that they're going to be able to get the rent for that semester. So I just wonder what your reaction to that is. I wasn't sure what to say.
That does exist from time to time, but I think it's just a timing issue. If we were to discover it at the beginning of the semester, I think it would be taken care of by semester end. Mm-hmm. But it does exist. But we are diligently out there looking for unlicensed rentals now. We have the city staff out there looking to help us do that. In the past, we weren't aggressively attacking these things, but we are now. Mm-hmm. And so, but also when we find them, they are property owners, and they have a due process that is due them as well. And so the timelines of the code are really what we follow. And I understand sometimes it doesn't feel good, but it is something we have to adhere to.
Let me ask this, in terms of the fines, you know, if you have the same person who owns a home who's doing that on kind of a regular basis, and they get fined for a violation of over-occupancy, and then that happens again, does the fine go up? Do they pay a larger fine because they've done the same thing over again?
That would be a court issue. I'm not absolutely sure of that.
I mean, is that something that we could write into our ordinance that would say, so that we could make it really a pretty high penalty at the point where it's obvious? I'm thinking, I mean, I don't know how much you could do, but I'm just wondering if we could make it so much of a penalty that a person the fact of facing maybe $1,000 or $2,000 might be something that would say, no, I'm not going to do this anymore.
The same principle you're talking about is why we went away from civil infractions to misdemeanors, actually. And we are getting some compliance now where we didn't in the past.
Yeah, that makes sense.
Yep.
Any other questions for the sergeant?
Lieutenant.
Okay.
Lieutenant, excuse me.
Fine. Vice Mayor.
Vice Mayor, yeah. Been called worse, that's for sure. Thank you for taking the time
you.
today to present to us.
Appreciate it.
Commissioner Ling.
The only other comment I would make is I think this kind of a presentation, which is very helpful in understanding the issues, would be a really good presentation to have in front of some of the neighborhood groups. Like perhaps, you know, Swan meets on a regular basis. Maybe a presentation like that at Swan would be useful. The Washington Street area has started, and then, of course, as was mentioned earlier, there's going to be this new super organization created that's designed to try to bring together the group. So I'm just wondering if maybe we could do some outreach and suggest programs at some of these neighborhood association meetings where they could hear the information and also be able to ask questions and share some of their experiences.
Good idea. Thank you.
Could we also post a link to the presentation on our website?
That's what I was just going to say. Our intent was to strip this part off and make that more readily available, because we know some of the planning commissioners and ZBA members would find it helpful as well, and we could just link it to them. So we will look at different ways to get that out there.
Good stuff. Commissioners, without objection, I'd like to adjourn this meeting.
I object.
Hearing no objections, we are adjourned at 9.